Florida Senate Bill 264, signed by Governor DeSantis on May 8, 2023, banned Chinese nationals from buying property in the state. On paper. In practice, every Chinese national who already owned property kept it. Every acre, every unit, every parcel remained exactly where it was. The law drew a hard line around the future and left the present completely untouched. That is the ownership paradox at the center of this story, and it deserves a moment before we get into the records. Senate Bill 264 took effect on July 1, 2023. The law prohibits individuals and entities connected to 7 designated foreign countries of concern, including China, Russia, Iran, North Korea, Cuba, Syria, and the Venezuelan government of Nicolas Maduro, from acquiring agricultural land anywhere in Florida. Purchases within 10 miles of any military installation or critical infrastructure face similar restrictions. For Chinese nationals specifically, those who are not U.S. citizens or lawful permanent residents, the law goes further still, imposing a near-total ban on acquiring any interest in real property across the state. That is a broad prohibition. Here is what it actually did to existing owners. Nothing. Anyone holding a covered interest in Florida real property before July 1, 2023, kept it explicitly under the law's own terms. They could not sell and repurchase, and they could not acquire additional land, but the property they already held remained theirs. The only obligation the law imposed was disclosure. Existing owners of non-agricultural real property had until December 31, 2023, to register with the Florida Department of Economic Opportunity, while holders of agricultural land had until January 1, 2024, to register with the Florida Department of Agriculture and Consumer Services. Florida did not confiscate anything. It created a registry. And here is where the data gets interesting, because no publicly confirmed count of how many existing Chinese-linked owners completed that registration has surfaced in official state records, at least not in a form that has been independently verified. The state passed a law, set 2 separate registration deadlines, and the full picture of who complied remains unclear in public view. For a channel that tracks ownership records, that gap is worth sitting with. Now, how significant is Chinese land ownership in Florida and across the country more broadly? This is where the numbers require care, because the headline figures in circulation vary considerably depending on methodology and year. According to the most recent USDA data under the Agricultural Foreign Investment Disclosure Act, known as AFIDA, foreign persons and entities collectively held an interest in more than 46 million acres of U.S. agricultural land through the end of 2024, representing roughly 3.6% of all privately held agricultural land in the country. Canadian investors hold the largest share of that foreign-held total at approximately 34%, or around 16.1 million acres, according to the same AFIDA 2024 report. Chinese-linked holdings account for less than 1% of the foreign-held total, according to a National Association of Counties analysis of AFIDA data from 2024. Precise acreage figures vary across sources, and the spread matters. Some analyses citing AFIDA data through 2021 put Chinese-linked holdings at around 383,000 acres, which represented a peak at that time. More recent AFIDA data suggests that figure has since decreased, according to the American Farm Bureau Federation's January 2025 analysis, with other current estimates placing active Chinese-linked holdings closer to 247,000 acres. The gap between those two numbers is larger than the entire land area of Rhode Island, which gives you a sense of how much the methodology shapes the conclusion. Where that acreage comes from also matters. A substantial portion of Chinese-linked U.S. agricultural land traces back to the 2013 acquisition of Smithfield Foods, the pork company, by WH Group, formerly known as Shuanghui International, in a deal valued at approximately $7.1 billion. That single corporate transaction means the overwhelming majority of what appears in the records as Chinese-owned farmland entered those records through one food industry acquisition, not through incremental direct agricultural land investment. In other words, strip out Smithfield, and the remaining Chinese-linked acreage looks considerably smaller than even the 247,000-acre figure suggests. Set the headline number aside for a moment, because the structure behind it tells a different story than the phrase, "China is buying American farmland," tends to imply. Florida's law did not emerge in isolation. The same national security framing appeared in Texas, where Senate Bill 17, the Lone Star Infrastructure Protection Act, similarly restricted property purchases by individuals and entities linked to countries of concern near critical infrastructure. And in Grand Forks, North Dakota, the Fufeng Group's attempted purchase of farmland near Grand Forks Air Force Base became one of the most prominent federal flashpoints in this debate, a case that drew Pentagon scrutiny and helped establish the political momentum behind state-level legislation across the country. Florida's SB 264 is the broadest and most litigated of those efforts, but it is one point in a pattern that now spans at least 22 states. Senate Bill 264 attracted a legal challenge almost immediately after passage. In May 2023, the ACLU, the Asian American Legal Defense and Education Fund, and the Chinese American Legal Defense Alliance filed a federal lawsuit in the Northern District of Florida, referred to as Shen versus Simpson, with plaintiffs including an Orlando-based real estate firm and 4 Chinese citizens. Their arguments centered on equal protection under the 14th Amendment and on the claim that federal foreign investment regulation through CFYUS, the Committee on Foreign Investment in the United States, whose authority was expanded under FIRMA, the Foreign Investment Risk Review, Modernization Act, preempts what Florida attempted to do at the state level. By February 2024, the 11th Circuit granted a limited preliminary injunction against enforcement of the law for 2 of the Chinese national plaintiffs, finding they had a substantial likelihood of prevailing on the preemption argument, which looked at the time like a meaningful early result for the challengers. The full 11th Circuit opinion arrived in November 2025, and the outcome shifted. The court concluded that the plaintiffs were unlikely to succeed on the merits, the preliminary injunction was denied, and the case was subsequently voluntarily dismissed, leaving Senate Bill 264 fully in effect. The court also clarified something that received little attention in the wider coverage, and that most reporting on this law has consistently missed. Purchase restrictions under SB 264 do not apply to Chinese nationals whose legal domicile is Florida, meaning a Chinese citizen who lives in the state and intends to remain there indefinitely may not be covered by the ban at all. That is not a post hoc loophole. It is a provision embedded in the law's own structure, a built-in exemption that complicates the straightforward ban framing considerably. Bethany Lee, executive director of AALDF, stated that the law harkens back to discredited century-old alien land laws that told generations of Asian Americans that this country was not their home. Representative Judy Chu of the Congressional Asian Pacific American Caucus similarly condemned the law as discriminatory against Asian communities regardless of citizenship status. Governor DeSantis described SB 264 as the strongest legislation in the nation to counteract the influence of what he called the United States' greatest economic, strategic, and security threat. Those are attributed positions from different sides of a contested debate, not conclusions this channel draws. The records show a law, a registry, and a legal challenge that ultimately failed. Supporters argue Senate Bill 264 mirrors the federal government's own CFI-US framework and addresses a genuine national security gap around military installations and critical infrastructure. Critics, including the Congressional Asian Pacific American Caucus, argue the law places a disproportionate burden on existing Chinese homeowners who must register property they have legally held for years, while doing nothing to address the structural corporate mechanisms, the Smithfield-style acquisitions, that account for the bulk of foreign-linked land exposure in the country. Both positions are on the record. At least 22 states enacted some form of foreign property ownership legislation between January 2023 and July 2024, according to available reporting, and Florida's version ranks among the broadest and the most litigated of those efforts. The law is standing. The registry exists. Whether the ownership picture it captured reflects a genuine national security concern or a politically constructed one is a question the records alone do not resolve. What the records do show is this. Florida drew a hard line, called it a ban, and grandfathered every existing owner straight across it, restricting the future while registering and preserving the present exactly as it stood. If the gap between how an ownership law gets described and what it actually does to existing holders interests you, that is the territory this channel covers.